Hello, welcome back. Today we're going to be talking about resulting trusts, and this is going to be a very quick introduction to resulting trusts. So, resulting trusts arise where the beneficial title in property reverts to or never leaves the original legal owner of the property. Basically, a resulting trust is always for the benefit of the original owner of the property. It may never leave the legal owner where the nature of the transaction is not to pass the beneficial title with the legal title, or may revert where the reasons for the transaction no longer exist or never existed. So, put another way, resulting trusts broadly arise in two different contexts. Either where the beneficial title never actually leaves the original owner, or where the legal and beneficial title do pass and then the beneficial title comes back at a later date. While the most satisfactory definition of the resulting trust remains a subject for debate, it is suggested that the resulting trust is best thought of as being limited to these two categories. In some cases, the beneficial title will revert because there's nowhere else for it to go other than to the Crown in bona vacantia. So basically, under English law, the general principle is that any genuinely ownerless property of whatever type, including, land, will revert to the Crown. But in practice, courts rarely make that determination that property is ownerless. Instead, they employ a number of devices, such as a resulting trust, to find an owner where there would otherwise be none. Okay? Right, so now let's take a closer look at how the court has tried to classify resulting trusts by looking at a couple of cases, beginning with this case here, which is in re Vanderbilts Trusts number 2. Okay, so basically, this was the first case where the court really tried to analyze and categorize the nature of resulting trusts. And in short, this is the case about whether, when the share option was exercised, the resulting shares were held on trust for Mr. Vanderbilt or for his children. And I've already made a 20-minute video on this case, so make sure you do check that one out if you're not already familiar with it. I understand that this case can be pretty tricky for people who are just reading it for the first time, so check out that video first, and then come back to this video once you've watched it. But the important point for us here is that in the High Court, McGarry explained what is meant by resulting trusts and draws a distinction here between a presumed resulting trust and an automatic resulting trust. Okay, so as he says, putting it shortly, in the first category, subject to any provisions in the instrument, the matter is one of intention, with the rebuttable presumption of a resulting trust applying if the intention is not made manifest. So where there's an intention for the original owner to retain the beneficial title or no intention to pass the beneficial title, then on the basis of that presumption, beneficial title will remain in the hands of the original owner. This is what we mean by a presumed resulting trust. Okay. So then McGarry continues by saying, for the second category, there is no mention of any expression of intention in any instrument or of any presumption of a resulting trust. The resulting trust takes effect by operation of law and so appears to be automatic. In other words, there are some circumstances where a resulting trust will automatically arise by operation of law. This is, of course, the automatic resulting trust. And as McGarry quite nicely summarizes at the end here, he says that what a man fails effectually to dispose of remains automatically vested in him, and no question of any mere presumption can arise. The two categories are thus of the presumed resulting trust and the automatic resulting trust. Cool, so I think that covers this case. And then we've also got the case here of Westdeutsche, Landis and Islington from 1996, okay? So in this case of Westdeutsche Landis, Lord Brown Wilkinson basically kind of sets out the same categories as McGarry did in the Vanderbilt case that we just took a look at over here. But he doesn't use the same, names of a presumed resulting trust and an automatic resulting trust. Instead, he uses the nomenclatures A and B. So as he says, under existing law, a resulting trust arises in two sets of circumstances. A, where A makes a voluntary payment to B or pays wholly or in part for the purchase of property which is vested either in B alone or in the joint names of A and B, there is a presumption that A did not intend to make a gift to B. The money or property is held on trust for A if he is the sole provider of the money, or in the case of a joint purchaser, by A and B in shares proportionate to their contributions. It is important to stress that there is only a presumption, which presumption is easily rebutted either by the counter-presumption of advancement or by direct evidence of A's intention to make an outright transfer. Okay, so this is basically a load of waffle, and it's a load of waffle to tell us that he agrees that presumed resulting trust exists. So, as one instance of this, where two people contribute to the purchase of property, that property is intended to be held on trust for those contributors by whoever is the common law owner of the property. So let's say, for instance, I buy a house for £500,000 with £250,000 of my money and £250,000 of my friend Matthew's money, and I have the house registered in my name at the land registry. It's presumed by the courts of equity that the house is held on resulting trust by me as trustee for myself and Matthew in equal shares. That presumption can then be displaced if some other intention can be proved. So, for example, if it can be proved that Matthew was only intended to make a loan of money to me, which I was to repay, then the house wouldn't be held on resulting trust, because Matthew would not be intended to take any equitable interest in the house. Okay, cool. Hopefully that makes sense. Lord Brown-Wilkinson then continues by exploring the other type of resulting trust. And he goes on to say, B, where A transfers property to B on express trusts, but the trusts declared do not exhaust the whole beneficial interest. This then corresponds to the automatic resulting trust that was talked about in the Vanderbilt case. So this resulting trust arises where there is a gap in the equitable title. Like if I declare a trust over property but fail to explain who will be the beneficiary under that trust, then the property will just be held on resulting trust for me. The underlying rationale for the law of trusts declaring such an automatic resulting trust is the underlying policy of English property law that there cannot be property which does not have an owner. Equity, as we may know, abhors a vacuum, and therefore will fill any gap in the title with a declaration that the property is held on trust for its previous owner on a resulting trust. So, in short then, if you have an express trust and there is no beneficial owner, then by operation of law, the settlor is the beneficial owner under a resulting trust. This then really leaves us with three main sets of circumstances where resulting trusts may arise, which we're going to explore in more detail in the next few videos. I know I've basically been saying, and McGarry said, that there's only two sets of circumstances broadly split into categories A and B, but he actually mentions two different types of type A resulting trusts. So really then we have the incomplete or imperfect trusts, which are essentially a type B or automatic resulting trust. So this is where we have the unallocated beneficial interest, which gives rise to an automatic resulting trust. We've also got transfers without value, which are type A or a presumed resulting trust. And we've also got a second type A or presumed resulting trust, which is the the purchase money resulting trust of property. So we're going to look at all of this stuff in the next few videos, but I'm hoping this video was fairly straightforward. If you've got any questions at all, drop them below. I'll try to get back to you. I get so many questions nowadays, so it's pretty difficult. But yeah. Oh, and one thing before I wrap up, it's also worth noting that the presumed and automatic trust nomenclatures have, sort of fallen out of favour by the judiciary. But, it's still worth being aware of these names, because you may come across them when you're reading textbooks, or maybe your lecturer's a bit out of date and still uses those names too. Anyway, That's it for now. Check me out on my socials, my website, and my other personal YouTube channel. And if you've got any questions, as I said, please do drop them below. See you soon.